Hi, everyone, and good evening. My name is Zach Austin, and I'm the chapter president of the Yale Federalist Society this year. Last year, I was the events officer with two other great EVPs, and it's good to just be back in the saddle again. I thought we left the days of Zoom events behind me, but Nationals was lucky enough to pull me out of retirement one last time to host the second iteration of FEDSOC's new Study Break series. Tonight, we're thrilled to be joined with Professor Sam Bray. Before I introduce him, I just want to say a word about tonight's format. So I'll be asking a couple of questions to kick off with. Then we encourage you as the attendees to jump in with some questions of your own. There's two ways you can ask. You can either raise your hand and I'll call on you and then have the opportunity to unmute yourself and then share your question. Or you can just submit them by chat and Q&A. And from that point, we'll roll right ahead and I'll read them along. With that, Professor Sam Bray is a professor of law at Notre Dame Law School. His primary areas of research are remedies and equity, but his published books demonstrate the real breadth of his scholarship. With various co-authors, he has published 4 editions of the Constitution of the United States, 2 editions of Ames, Chafee, and Ray on remedies, Genesis 1 through 11, a new old translation for readers, scholars, and translators, and the 1662 Book of Common Prayer, International Edition. Professor Bray received his JD from the University of Chicago Law School and clerked for then Judge Michael McConnell on the U.S. Court of Appeals for the 10th Circuit. After clerking, he practiced law at Mayer Brown, was an associate in law at Columbia Law School, and was executive director of the Constitutional Law Center at Stanford Law School. Professor Bray was an assistant professor of law at UCLA from 2011 to 2016, and a professor of law from 2016 to 2018. And then during the 2016 to 2017 academic year, he was a Harrington Faculty Fellow at the University of Texas, Austin. So Professor Bray, welcome. Tonight's theme is nationwide injunctions. And with that, I have a brief question. I think all of our legal education was brought to a rapid halt because of the COVID-19 pandemic. You can call that a kind of national injunction on our learning. Could you share with us just some of your experiences from the Zoom classroom over the last year? Anything that, if we have another once in a century pandemic in the next 2 years, you'd like students to really remember going forward?
Oh, well, it's great to be with you all tonight. I'm happy to be here, happy to talk about all these things, including being on Zoom, which I think most of us are probably, our sort of Zoom quotient is all filled up, except for tonight. So happy to be with you. I think for me, the hardest thing was teaching hybrid. So teaching all by Zoom, like this discussion worked great. Teaching in class worked great. In class I like more, but the really hard part was when like half my students were on Zoom and half were in the class. And if as hard as that was for me to teach, it was harder for the students because one of the things that immediately dropped out was all Socratic questioning. And so it was really hard to manage both. So I had to switch in one class. I switched to doing pure lecture. Usually I do a lot of questioning, and I switched to 100% lecture. So that was probably the biggest challenge. But I mean, compared to losing loved ones or getting really deathly ill, it was clear sailing.
Yeah, absolutely. Well, 2020 was a noteworthy year for you as well. I know you obtained some publicity when Justice Ginsburg cited your amicus brief in Rotkowski v. Clem, where you discussed equity, not really in the politically correct sense, but in the civil law sense. This was also the year, if I recall correctly, that you taught the first equity course at Notre Dame in more than 60 years. So while we're on the subject of legal education, why do you think equity just fell out of law school teaching? And what do you think students gain by re-engaging with it?
So I think there's a myth that 1938 changed everything. And once you have law and equity merging for procedure, that suddenly this means equity doesn't matter. And I think that's not true. If you want to cite for that, Petrella is this great copyright case involving the script for Raging Bull, the movie, and it's all about equitable defense of latches. And Justice Ginsburg writes the opinion. She says 1938 doesn't change equitable defenses, doesn't change equitable remedies. They're still equitable and apply to equitable claims just like before. So I think the big problem is that myth spread, and then equity falls out of the curriculum. And then once it falls out of the curriculum, people don't know it's there, and that suddenly leads to people thinking equity is this like big scary thing, and it's just judicial discretion and judges doing whatever they want, rather than recognizing like what's the line from The Big Lebowski? This isn't NAM. There are rules. So that's true of equity too.
Well, speaking of big scary things, how about a question on the nationwide injunction? So one of the terrific points you raise in your writings on the subject is just the ahistorical nature of courts trying to take on this power. You wrote this Washington Post op-ed where you called the theoretical underpinnings of the rule the someone is wrong on the internet theory of national injunction. And as someone talking about why people are wrong on the internet right now, I tend to find these arguments pretty compelling. So what, in your opinion, is the best version, the steel man of the pro-nationwide injunction argument? Is it that nationwide injunctions achieve some good purposes, or is there really some historical justification for the practice at its core?
So what you just laid out, Zach, are basically the two counter arguments to my position. And one is the history. We've been doing this for a long time. The other is there are important constitutional values at stake. I think the history claim does not hold up. I think what we've been doing for a long time was equitable actions like bills of peace, where one person gets to represent other people. And there's just basically a through line from that to the development of the class action. Like that's where the class action comes from. And if somebody's representing other people, that's okay. And then you make sure the person's a good representative. But the national or nationwide injunction is not like that. So I don't think the historical arguments hold up. I think that it's a new thing. I think it first happens in the middle of the 20th century, and it really doesn't get rolling until the late in President Obama's administration. So it's new. I think the best argument on the other side is that you will lose protection for constitutional values, that there will be losses where the government acts unconstitutionally, and it's just hard to restrain it if the scope of the remedy only runs to the plaintiffs. These are arguments that have been made by Amanda Frost and also by Mila Sahoni. And I think that argument is the strongest counter on the other side. And it's one of those, like often happens in law, you can't have everything. Like if you keep judges in their lane, then you don't get the benefit of judges outside their lane doing good things.
Yeah, absolutely. And I'm mindful of the fact that we have students really from all 3 years of law school joining us. So with that in mind, could you maybe just lay out, what is a nationwide injunction, and then maybe why you think they're not really in line with the historical practice?
Sure. So the key thing about a national or nationwide injunction is not geographic scope. It's not that it is nationwide, because if you have a trademark and I'm violating your trademark and you sue me and you get an injunction against me, then that injunction could likely stop me from violating your trademark anywhere in the world. So it's okay that its geographic scope is broad, but for that injunction, it would be against me and it would protect you. So it would be an injunction that would protect the parties. And the problem with the national injunction is it's where somebody goes to court and gets an injunction that shuts down what the federal government is doing everywhere with respect to everyone, whether they're parties in the case or not. It's a kind of illegitimate class action. It's like one person getting to act for the class without actually meeting the requirements for a class action. So I think there are lots of problems with it. Some of those are constitutional problems. It runs beyond the judicial power, because once a court has decided the case between the parties, there's no more case left. It's not like the court can just go on and do good things. And then there are things like the end run around class action, and there's lots of forum shopping. When Republican state AGs want national injunctions, they all run to Texas. When Democratic state AGs want national injunctions, they run anywhere but Texas. And it's a problem.
Yeah, absolutely. Speaking of the class action, one of the things that FEDSOC is trying to do through this series is just get at what students can do in class and what actions they can take. So I was hoping you could answer sort of a mystifying question that law students everywhere have. Could you walk us through the process of writing a law school exam? what goes through your mind? What are you thinking about? And what advice would you give students who are trying to tackle one, maybe for the first time, for grades, if they're coming from my esteemed Yale Law School?
Right. Okay. So when I draft an exam, well, there's a deadline for my associate dean telling me when I need to turn in an exam, and so several days before that, unless I've had an idea, I start working on it. I don't want to. I tend to ask 3 questions, and 2 of them are issue spotter questions, and then 1 is going to be a policy question, and they're going to be on big important stuff from the semester, not trivia. I think the biggest piece of advice would be to, especially for 1Ls, is realize just how different your professors are in their expectations. So some professors grade an exam with a checklist. So they've got like, here's a list of 20 points that you can get on this question. And they're going to read your exam, they're going to look for the 20 points, and they're going to like put checks by them if you run across them. Now, if that's the way somebody's grading, then what you want to do is say as many points as you can, make as many points, because that's the way you get the points on the score sheet. I don't do that, and some other professors don't. I don't want to hear the really low probability arguments. Like, I don't want your 20 best arguments, because you're not going to do that in practice, right? You tell the client, like, we got this argument. If the Constitution was not validly ratified, then maybe we could argue. No, just no, cut it out. So, like, give me your best argument, give me your next best argument, maybe give me 1 more, but not the low probability stuff. So you just need to figure out what your professor wants. And some professors want different approaches to that. Also, the prompt is really important. Read exactly what the question is. Don't answer almost the questions being asked. Answer exactly the right question.
Yeah, absolutely. That's great advice. And something I wish I would have heard before I embarked on my first graded exams. That was a 2.0 year thing for me, though. We actually made it through the first year of Yale Law without any grades at all. We were all special snowflakes at heart. I'm going to ask one last question before we turn over to audience Q&A. So some of our students on the line might know from your testimony to the Presidential Commission on the Supreme Court of the United States, where you testified about the growing use of the shadow docket. Could you just talk about some of your goals when considering your testimony in front of the commission? And did you find that commission particularly receptive to either your testimony or the concerns you raised?
So I did find the commission receptive. Of course, I'm on the outside. I'm not one of the commissioners, so I don't know what their internal deliberations were. But they did have a wide range of people, a wide range of ideological views speak. I think that speaks well of the commission. So what were my goals? So what I'm going to do here is I'm going to sort of let you behind the underneath the hood, under the sink, behind the veil, whatever the right metaphor is. So here's how I thought about it. There are a certain number of things that I could say, points I actually think. You should never say anything you don't actually think in your testimony. So there's a wide range of things I could say. Then there's a set of things that they're interested in hearing about. Like, they want to hear about the emergency docket or shadow docket or orders list. It's got different names. So they want to hear about that and what courts are doing on that. And then there are a certain set of broader aspirations I have for the law that might dovetail with and meet the moment for what they're concerned about. So the Presidential Commission is looking at ways to trim the wings of the Supreme Court, for example. Some of the ways they're thinking about, like packing the court, I think are while not unconstitutional, are basically illegitimate subversions of our political order. And that applies no matter who's doing it, Republicans or Democrats. So I don't think packing the court is an appropriate response. I agree with the critics of FDR's attempt to do that in 1937. But one of the points that might mesh with what the commission is interested in, that I also strongly think, is that interpretive authority for the Constitution does not just belong to the courts. It's the Constitution of all 3 branches, and it's the Constitution of the people, ultimately, not even of just of the government. Now, I think Madison's right that as a practical matter, the Supreme Court will often have the last word. but it doesn't have the last word on an issue just because it has the last word in a case. This is the great insight of Abraham Lincoln arguing about Dred Scott. So I'm on the Lincoln versus Dred Scott side of thinking about judicial power. So this is a great opportunity to say, executive branch, legislative branch, you're really worked up and concerned about what the Supreme Court is doing. So here is an important part of our constitutional tradition that can help you. Don't say that the Supreme Court has exclusive interpretive authority, judicial supremacy. In fact, take the opposite tack and say it has authority, but so do the other federal branches, and for that matter, the states and the people.
Absolutely. All right, turning to student Q&A, we have a written question here first. Just as a reminder again for all of our attendees, you can feel free to submit written questions by the chat or raise your Zoom hand, and I'll call on you and get you in line. So this one is a doozy. Some scholars and at least one court of appeals opinion have responded to your arguments by saying that there is a substantial historical basis for nationwide injunctions. For instance, Mila Sahoni cites Lewis Publishing Co. v. Morgan as an example of a universal injunction by the Supreme Court. And as you mentioned, Amanda Frost identifies bills of peace issued by English courts of equity as an example that, as she says, courts have always had the authority to issue equitable relief that encompasses non-parties. How would you respond to those specific examples of historical counterarguments?
So in addition to those two sources of historical critique, there was also a historian's brief filed in support of national injunctions in a Seventh Circuit case that had some really great historians on it, including Amalia Kessler, Bob Gordon, Kellen Funk, and others. So the historical critique has been raised in several places. If you want to read more, my responses I had a two-part response to the Seventh Circuit brief. That was the Bollock conspiracy. And I also wrote a response to Professor Mila Sahoni's paper that was at the Yale Journal of Regulation blog, notice and comment blog, cross-posted at Bollock conspiracy. So I have long responses at both of those. The short version is the various cases that Professor Sahoni cites for national or nationwide injunctions as opposed to like statewide don't hold up on closer inspection. So the Lewis case, for example, was a case where the government had made a promise to all the members of this trade association that it wasn't going to prosecute anymore under this statute during the pendency of the litigation. And then they went back on it. And then the defendant said, like, Supreme Court, like, hold them to their contract to do this. And then the SG's office seems to have just admitted that that's right, that is what they had agreed to. And then the Supreme Court requires them to do it. So this is just like almost a kind of a estoppel on the promise they had made. It doesn't say anything about what the authority of the court would be in the absence of that. The next major case that is cited comes from, if memory serves, the 1940s, and it's a case where the Supreme Court specifically calls out the district court for this like crazy broad injunction, and it says it's too broad. And Hugo Black is sort of like stammering in disbelief that the district court thought it could do this. So, like, to me, these are exceptions that prove the rule. If this is what you can come up with. As far as the Bill of Peace goes, that is an antecedent, but it's not an antecedent. It's an antecedent for the class action. And then the question is there still a possibility of doing something like the class action that is outside of Rule 23? And the court has actually addressed that question before and said no, that you can't. If you're going to do a class action, it's got to go through Rule 23. So I think that's if you want to trace it out, you can work through the federal equity rules, the 1840s ones, the 1912 ones, and follow along the development of these representative suits from the Bill of Peace to the class action. But that's what it is today.
Yeah. Maybe just a follow up there. So in one of your statements before the Senate Committee on the Judiciary, you said that my hope is that the Supreme Court will end the national injunction or that Congress will. So I'm wondering, would the effects be different depending on whether the Supreme Court or Congress is the one that strikes nationwide injunctions down? And do you see one body or the other as maybe the better one to bring an end to this practice?
So this is a hard question. There have definitely been huge debates over the use of federal equity powers before. And sometimes those debates have been resolved by Congress shutting down what the federal courts were doing. So an example of this is the labor injunction used to stop strikes in the early 20th century, 1890s really, up until the Norris-LaGuardia Act in the 1930s. And there was some intermediate legislation that limited it as well. So, so it could come from Congress, and Congress has the right under Article 3 to define the jurisdiction of the federal courts, make exceptions and regulations. If Congress does it, then I think you're more likely to, it's more likely to have a crisp edge. It's also more likely to have one of the various compromises that have been floated, like channeling everything to DC, the DC Circuit, or making courts give injunctions that run beyond the party but are within the jurisdictional territory of the court, like the Northern District of Illinois, within the Northern District of Illinois, that kind of thing. So those would be more likely in Congress. But what would be less likely is some kind of in exceptional circumstances safety valve outlet. And I think the courts are more likely to leave that for themselves if they do it. That would be my worry there. My hope is if Congress did it, it would shut it down completely. If the courts did it, they would shut it down completely. But the nature of the partial success is probably different across those two bodies. As to which one is more durable, if it's from the courts and it's a constitutional holding, and that would fit with what the court has said about its constitutional power to give remedies in some other cases, like Gill and Whitford, partisan gerrymandering case, then about the power of the court being to remedy the injuries of the parties, then that would probably be a more durable holding. If it's about the Judiciary Act of 1789 and federal statutory jurisdiction, then that could be changed by Congress. The problem with Congress doing it, though, is that I think Republicans really don't like national injunctions when Democrats get them, and vice versa. That's just part of how the political process works. You want judges to be more principled than that, and you want legal scholars to be more principled than that. You should be against them if they're wrong and for them if they're right, regardless of whether they favor your team on any particular policy issue.
Yeah, absolutely. So the next question is, since courts of equity began in England as quasi-judicial / executive bodies, does the use of an equitable remedy by an American court definitionally violate our nation's most strict separation of powers? Or is there a way in which courts can issue equitable remedies without implicating executive power at all?
So there are sort of two different questions going on here. I think there's a question about the English practice, and then there's a question about how you translate that English practice into contemporary US practice. So as far as the English practice goes, I wouldn't say it's quasi-judicial, quasi-executive probably after the restoration of the monarchy around this, probably when Chancery, certainly by the end of the 17th century, I'd say we're looking at something that's pretty strongly judicial and not executive. The executive sense is very strong in the late Middle Ages, and then it just gradually runs out a little bit. So by the time of Lord Chancellor Thurlow, who's the chancellor at the time of the American Revolution, by that time, I think it's pretty clearly judicial. Okay, so does it violate separation of powers just to give an equitable remedy? I don't think so. Now, in part, that answer is predetermined by my answer about like what's going on in England. But this was a matter of serious debate at the founding. Like, there was a lot of concern about courts of equity. Brutus, in his essays about judicial power is really concerned about equity. He says, like, courts are going to get the equitable power and then they're going to go crazy. And Hamilton writes about this, and the Federalist says, no way. Equity is a system. There are principles, there are precedents. It's all sort of worked out. It's not going to be craziness. So I think the question then is whether federal courts, using their equity jurisdiction, use these principles and practices derived from English practice. Not that they have to be exactly the same, not that there can't be change. There can and always will be in a tradition. So I don't think you shouldn't be an originalist about equity. You should be an originalist about the Constitution. But equity, there's no like text for you to read. Like, here's the text of equity that was ratified in 1789. Like, there isn't one. So you're not in text land, you're in a tradition land. And that inevitably means there's going to be more development and fluctuation. But still, the legitimacy of federal courts' use of the equity jurisdiction depends on their ability to trace it back to historic practice. So I think that's the check, rather than a kind of pure separation of executive and judicial powers. Though I do think, like, one last thing on this question. It's a rich question. I think there is something a little bit executive about the managerial powers of equity. So when equity appoints a master or a receiver, you can do this in private law cases, it can do it in public law cases. But when you've got that kind of official appointed, that official looks a lot like an executive officer, but doing the work of a court.
Maybe just building on this one, because you're right, it is a rich question. One of the arcs we've seen in the tradition of American jurisprudence is a move away from separate state court systems revolving around law and equity towards sort of courts of general jurisdiction. And you see just a few states holding on to the old way of doing things, particularly Delaware. What are we to make of that historical story? Is there still a role for equity in American jurisprudence at all?
So I think there is. There are currently 3 states with separate courts, Delaware being the most well-known, Mississippi and Tennessee are the other 2. There are a number of other places where the distinction is still reflected in judicial institutions, like New Jersey has chancery divisions, Cook County, Illinois, where Chicago is, has a separate chancery court. Iowa has a constitutional separation of law and equity jurisdictions. There are different appellate rules, I think in South Carolina or Georgia or both. So there are some differences still, but on the whole, the trend is exactly like you say, toward merger. Virginia and Arkansas were 2 of the states over the last 20 years or so that merged. So what do we make of it? I think part of what we should make of it is it's one more example of a kind of pipe dream or fantasy in American law, that we can just do this change and then it's going to be simple and everybody's going to get it and everybody will understand the law. Like, there's this old story, I think it's in Suetonius and maybe some other places, about one of the Roman emperors who, like, you want to know how bad he was. Like, not only was he going around killing people, but what was really bad is he took the Roman laws and he put them way up on top of pillars, high pillars where nobody could see them, but they were still accountable for them. Okay, so that's like bad man, villain of lawmaking. So let's stop that. And Bentham says the common law is like that. You hide the law from people. They got to go read the judicial opinions. They can't figure it out. Let's just codify. Let's have statutes that just tell you all what the law is. And then it's really simple and easy. And you know what? Good luck now, like your aunt or uncle who's not a lawyer, like turning them loose on a statute book, like, or just like giving them your Westlaw password to go like read some statutes so they can know what the law is. Like, it's not going to work. It was a fantasy. And I think a lot of the same ideas behind the merger of the courts. So if we can just get them together, then law is going to be simple and everybody's going to know what to do. Turns out it's not like that. You still have to do equitable remedies. You're still going to have equitable defenses. You're still going to have some equitable claims. Putting the courts together doesn't really change that. What it does do is it reduces expertise and specialization. So, so I think there are some benefits, there are some costs. It's hard to sort it out. If you press me on what was like the best way to do this institutionally, I think the best is probably what the federal courts had before 38, which is one court with two separate sides. So a side for law and a side for equity. And what that does is it means when courts are deciding equity cases, they're putting on an equity hat. And so it increases their equity consciousness. They're like aware of what they're doing. They're aware of this mode they're in that helps it stay exceptional, that keeps it in its lane. Other people think this view would be completely crazy, but that's sort of where I'm at right now.
And I want to flip a little bit to the other side of our conversation about just going through law school and being a Federalist Society student. So I know there are times that in certain classes, our members can feel like the law is sitting on top of the pillar, and it's hard to demystify and make its way through. So could you talk a bit about outlining strategies that you thought particularly effective in law school? Did you study in a group? Were you kind of a lone wolf? What worked for you?
I did sometimes study with other people. I had friends was in a study group with, but I think I mostly studied by myself, especially in upper level classes. I was a terrible outliner. I was a slow outliner. I was just like interested in rabbit trails, probably why I'm a professor. And I think I'm not sure that I completed my outline for any of my 1L classes. I think I tried and I got like substantially done, but I don't know that I actually got all the way through. So I think I'm not your outlining success story. I like the first rule of outlining is finish the outline, right? So like I haven't done that. So so I mean I just like enjoyed law school. I enjoy reviewing my notes, but I would like to do it without the pressure of the exam. But so I think that would be my confession and avoidance of the question.
Well, for those like you and me, you're in good company on this front that might not necessarily rely on an outline every time. What do you do when all of your peers are doing that? I mean, are you just sort of rereading your class notes all the time? I'm taking very selfish
I did
notes.
try to outline. I worked on an outline. I just like, they were huge and long, and I like I'd want to research this, and there'd be an article in the notes, and I'd want to read it, and I never got all the way through it. So it's not like I was like saying not gonna outline. So I do think there is a value to outlining, and the key is that it's forcing you to go from the micro to the macro, to the micro to the macro, back and forth, or the wood to the trees, or the wood or the forest to the tree. So that move is really important for a lawyer, and that is sort of what an issue spotter question tests, because what it's doing is giving you a micro and testing your ability to reason it up to the macro level, make sure you've got it situated in the right place, and then to connect it up with any other micro dots that it needs to be connected with. So issue spotters are really good at that. And this is one of the ways in which issue spotter exams are really good preparation for practice, because that's exactly what happens in practice. Like somebody walks in, like they're like she's not going to tell you what tort doctrine is implicated. She's going to say, like, here's what happened to me. And you're going to have to figure it out. You're going to have to go from the micro up to the macro, make sure there aren't any other trails you have to follow. So that's basically the skill that outlining is helping you develop. And that's true whether you finish the outline or not. The process of outlining, this is one of the reasons why you want to do your own work on your outline. It's okay to get somebody else's outline. It's not a problem. But but the real work, the real value is that up and down oscillation of perspective. And you can only do that by doing your own, not by just reading somebody else's.
Absolutely. When we were preparing for these talks, speaking of preparation, we were asked to bring along some swag from our chapter. So I brought a prop. These are our little Yale Federalist Society mugs. And my next question comes from the
Oh,
back of our
let me
mugs.
stop you just a second. Mid-mug, there's something I've heard about the Yale Law School chapter. Something about the Yale Law School chapter and an award it may have won this year. Is it true?
It is true. We did receive the Chapter of the Year award this year, which we're really excited about.
Congratulations. That's great.
It was a much more glamorous stage than everything you're seeing before you, to those in the audience.
Okay, I cut you off mid-mug. Feel free to continue your question.
Mid-mug. Well, there's a question we put on the back of all of our mugs, which I want to read to you now. And it's, are you now or have you ever been a member of the Federalist Society? And then maybe building off that, could you just talk a little bit about what your experience was like as a student in FEDSOC?
Sure. Federalist Society was a big part of my intellectual experience of the University of Chicago. That's where I went for law school. And I was chapter president my third year. And a lot of the intellectual formation was, of course, through my classes, through my professors. But a lot of the engagement and debate also happened outside of that. So that was in FEDSOC, that was in ACS. We co-sponsored a lot of events, so that was great. So, so from my perspective, the bringing in speakers who would be intellectually probing, especially views that might not be represented on the faculty or in the classroom, that's especially important. But I also, and here I'm just like gonna straight up give advice to everybody running student FEDSOC chapters. Don't bring in political hacks. Focus on people who are going to give you the best intellectual arguments on all sides of issues. So that's important, because what you're doing is ultimately shaping your mind and your fellow students' minds, and you're getting exposed to new ideas and the best forms of argument. So that was important for me. And it's really hard for me to imagine what my law school experience would have been like without that intellectual engagement from FEDSOC. Also formed really good friendships from it.
Yeah. One of the interesting features of the Yale chapter is that we actually have a student-run reading group for credit every semester. And so there are two people on our FEDSOC board who are sort of assigned to be our professors every year, which always creates a really, really fun interaction when it comes around exam time. You know, there's a real chapter president who will emerge in about May or so when it comes time for me to get my grade. But you know, speaking of that, I think curriculums can vary widely, sort of across all of these different institutions. So for example, I wrote this paper for the Federalist Society, and there's a line at the beginning of it that says, "Remedies is the garbage can of legal education," quoting an article from a remedies instructor trying to describe the subject to someone else. Do you have any advice about, you know, what are like must-take classes that students should try to do? Or what are particular classes that, on the other side of the coin, you don't hear recommended very often, or you don't often see in a course catalog, but that you might have seen and found really rewarding?
Oh, there are so many interesting ways to take this. I mean, you don't have very much time in law school. It may seem like it's a long time, but you don't really have that much. So part of what you want to do are take classes that other classes will build on. Fortunately, that's basically your 1L classes, except at the rare school that doesn't require property and should in the 1L year. That's usually going to be your 1L classes. Then you want to take some classes on whatever you expect you're going to do. Like if you expect you're going to do litigation, or you're going to do administrative law, or you're going to do whatever, like obviously double down on that. But if you approach this like you're sort of like a venture capitalist about your time, then you want to make some predictable bets, but you might leave a little bit of room for taking a flyer on something that's like kind of counter-cyclical risk, or something that's not going to be like what you expect, but you don't know if you'll love it. So for example, I never took tax. Then when I was summer associate and then associate at different firms, the tax people loved their work. It was completely consuming. Like you couldn't really, I only know one person who's successfully been able to be like half a tax lawyer and half something else. But you usually have to be all in. But there's this beautiful, all-encompassing system, and they loved it. So who knows? Maybe if I had taken a tax class, that would have been open to me. The fact that I never did, like it's pretty hard to make a compelling case that you're going to be a tax attorney if you've never taken taxes. Like, what are you going to say? Like, I use TurboTax, like hire me. So, so you can't really do that. So, so I think one way to do it is to like the things that you don't know about, but if you did know about them, you might really like them. Like do a little bit of sampling like that. If you're going to be a litigator, you should take remedies. I did not take remedies, but once I got into practice, I really needed it, and you'll need it too. One of the formative classes for me was my 1L elective, and it was Roman law with Richard Epstein. And what we did was we basically read a whole lot of Gaius and Justinian, and we were trying to figure out what the social and material context was and legal context that would make these rules make sense. And so it's kind of like a law and econ take on primary Roman law sources. And that's not the way most Roman law scholars would teach that class, but it was an absolutely invaluable training because that's something lawyers need to do all the time. You always need to start with a assumption that there's some kind of rationality to this system, and you've got to figure out what it is. Like, what is the background against which we set this legal rule that can help us make sense of it? And so I love that class, and it's one that I think has influenced how I think. The mischief rule paper can probably be seen as like a long-term echo of what I learned in that class.
And for perhaps a final question this evening, if just on the precipice of the abolition of the Nationwide Injunction, you were given the power to enjoin the teaching of one subject or case in all legal education, what would you do?
Enjoin the teaching of one subject or case?
Yes.
Oh, goodness. I mean, part of me wants to say there are so many, but what would be the one case? I can tell you the case that I found. Like different people have different things that bother them. There are cases you may find very morally upsetting. There are cases you may find very economically irrational. There are cases that may puzzle you for different reasons. But the case that I remember being most bewildered and sort of appalled at its like internal coherence was Veith v. Jubileer, which was a partisan gerrymandering case before the court closed the door on partisan gerrymandering. It was about 20 years ago. And the Kennedy opinion concludes there is no justiciable claim, justiciable basis for shutting down partisan gerrymandering. But there might be one in the future. So the answer is no, you lose. Future litigants will lose, but please continue to bring this litigation because maybe it will emerge. And I would be happy to prohibit the teaching. I don't know. I don't want to prohibit the teaching, even of bad examples. And there really are so many more like really worse cases. Like Dred Scott is so much worse than Veith v. Jubileer, but you know, I don't want to say don't teach Dred Scott. I teach it in common law. You've got to go face to face with constitutional evil. So I don't know. I'm fighting the hypothetical.
Well, Professor Bray, I think the much more charitable way to look at it is that you're a man of principle. You just do not support the Nationwide Injunction in any form, even when the power is given to you. And we can all take a lesson from that. But thanks again for joining us tonight. It was such a pleasure to talk with you. In the spirit of continuing to bring litigation, now that we are teaching the case still, we hope you'll continue to attend our study break series. The next one is going to be hosted a week from today, same time, same place. And it'll be the ASU student chapter hosting Professor Alexandra Harrison for a conversation on Bitcoin and cryptocurrency regulation. So buy your Dogecoin now, see how it turns out. We'll come talk about it in a week. Thanks for everyone for joining. Great to see you all tonight.
Bye.